Can an executor sell a house without court approval in Texas? The answer is sometimes yes, but only if probate was set up in a very specific way. If you're dealing with an inherited house in Austin or Central Texas, my name is Nate Clark. I help executors and heirs sell inherited property every week. This question comes up all the time. In Texas, whether an executor can sell a house without court approval depends on how probate is set up. There are two different ways that it can be set up. One is independent administration. The second is dependent administration. In most Texas probate cases, the court appoints what's called an executor under independent administration. What that means is once the executor has their letters testamentary, they can act on behalf of the estate without the court's approval, which means they can meet with a realtor, sign a listing agreement, put a property up for sale, accept an offer, and close on the sale without going to the judge for approval. And that's how most probates happen here in Austin. In a dependent administration, the executor actually has to get court approval before going through with a sale. This usually happens when there's no will, the will doesn't provide for independent administration, or there are disputes between the heirs to the estate. In these cases, the executor has to file a request with the judge, get the judge's approval, and typically have stricter circumstances in which they can actually sell the property. It goes without saying, anytime the court has to be that much more involved, this makes it take longer and adds complexity to the whole process. An important reality check, here's what a lot of people miss. Even if it's independent administration and the executor can sell without having to get the court's approval, they still have to get their letters testamentary and be officially appointed by the court as the executor that can act on behalf of the estate to sell the house. Until the letters testamentary or letters of administration have been issued, they can't sign anything, they can't accept an offer, and they can't close on the house. They don't have legal authority to do so. Having a will is not enough. They need legal authority. So yes, in Texas, an executor typically can sell a property without the court's approval, but only if they've actually been appointed executor by the court and if the probate allows it. If you're not sure what type of probate you're actually dealing with or if an executor has been granted power with, this is something I help families figure out all the time. My contact info is down below if you want any help walking through it.